Welcome everyone to today's webinar session regarding the changes to the Real Estate Industry Award. We'll just start off with a quick video before we get into the presentation.
What are the changes to the Real Estate Industry Award? New employees may now only be engaged on a commission-only basis if they pass a minimum income threshold amount, or MITA. This must be equal to 125% of the employee's annualised minimum wage. To enter a commission-only agreement, an employee must have passed their MITA for the previous 12 months. Employees on commission-only agreements must now have their contract reviewed every 12 months. If they fail to reach MITA across that period, the commission-only arrangement must end. Casual employees can't be engaged on a commission-only basis, and employers are not permitted to pro-rata the MITA for part-time employees. Commission-only employees are now required to be paid for periods of leave at the time the leave is taken, ending the all-up commission arrangement. In some circumstances, payment for all types of leave may be treated as a debit on the employee's account. New documentation rules have been introduced for all commission payments, bonuses and incentives, and the employer must give the employee a signed copy of every agreement. These rules apply when signing the initial contract and whenever adjustments are made during employment. Broad job classification means employees are no longer classified by reference to job title, but according to skills and responsibilities, meaning a review of current employees will be required. Pay rates across all categories of the Real Estate Industry Award will increase. This is a major change to be across to avoid underpayments. New employee allowances have also been added regarding transport by motorbike and use of mobile phones. This is only an overview of the changes. Get in touch with us at Employsure to find out exactly how your business will be affected.
Okay, so I'd just like to point out that a copy of the recording will be provided to you, but do feel free to ask any questions using the question box and we can run through those at the end. So as you already know, I am Stefannie. I'm one of the senior advisors here at Employsure. As a member of the advice team, I can confirm that we do work hard every day to provide our clients with timely advice on a broad range of employment relations topics. Generally, business owners become aware or familiar with the employment relations system because something has gone wrong or they have been exposed to an authority like the Fair Work Ombudsman for an underpayment claim, or the Fair Work Commission because an employee has made an unfair dismissal application. If you get it wrong, you can end up underpaying, paying too much, or facing big penalties. So given these complexities, employment relations and the relevant legislation, it is often very difficult to understand and interpret unless you are an expert. So at Employsure, we provide you with the assistance and the advice to achieve peace of mind and a fair and safe workplace. So the Fair Work Act is the umbrella which provides a minimum safety net of basic entitlements for all employees. This is leave entitlements and protection from unfair dismissal. Next to the federal system, modern awards, which sit above the Act, they regulate minimum conditions of employment in certain industries like real estate, and they include minimum rates of pay, ordinary hours, penalty rates and more. Such matters can obviously significantly impact your business. Then we move on to enterprise agreements. They contain conditions similar to awards, including minimum rates of pay, ordinary hours, penalty rates and more. However, they are jointly established between employers and employees, typically in a workplace. And then sitting above all of this is employment contracts, which set out the terms and conditions of employment. Employment contracts set clear expectations with wages, leave entitlements, provisions like annual leave and personal leave, how to terminate the contract, what notice period is required by either party, where the work will be conducted, and much more. Then we've got the National Employment Standards. So all employees in the National Workplace Relations System are covered by the National Employment Standards, which are commonly referred to as the NES. The NES are 10 minimum employment entitlements that must be provided to all employees. These include maximum weekly hours, which, as you may be aware, is 38 hours, requests for flexible working arrangements, for example, parents requesting changes to start and finish times, parental leave and related entitlements, so that will include maternity leave, paternity leave, adoption leave, and the employee's right to return to their old job. Annual leave is included in the National Employment Standards, which, as you may be aware, for a full-time employee is 4 weeks per annum, and with part-time employees, they receive that entitlement on the pro-rata basis. Personal carers leave and compassionate leave are a National Employment Standard entitlement. And when we look at sick leave, the entitlement combines leave for personal illness as well as to care for a family member, whereas compassionate leave is it's commonly referred to as bereavement leave, and it's the provision of leave for when a family member or a household member dies. There's community service leave, which quite commonly includes jury duty. Long service leave, which each state actually has its own legislation for long service leave. Public holidays, again, each state will have their own list of gazetted public holidays, which will also include show days for certain states as well, or areas. The 9th NES is notice of termination and redundancy pay. That's based on an employee's length of service with the company. And then finally, the 10th is the Fair Work Information Statement, which is a short document, but it does need to be provided to every employee on their commencement. It provides employees with information about their conditions of employment. So the national minimum wage and the national employment standards make up the minimum entitlements for employees in Australia. An award, employment contract or enterprise agreement, as we touched on in the previous slide, cannot exclude the national employment standards, nor can it provide for conditions that are less favourable than the national minimum wage or the national employment standards. So moving on to employee entitlements, we'll look at some of the key employee entitlements in a little bit more detail, some of which we've just touched on, and this will ensure, I guess, in assistance with compliance with them. So as you can see, employees have a significant number of entitlements. You might not be aware or fully understand all of them, but they certainly can affect how you manage your business on an everyday basis. So if we start with minimum pay, the awards will set out your employee's minimum rate of pay according to their relevant classification. If your employee is not covered by a modern award and they're subsequently award-free, then they're entitled to the national minimum wage. In addition to wages, awards can also stipulate allowances, overtime and penalty rates that may be payable on top of the minimum wage. Moving on to health and safety, it's governed by state legislation. So employers must ensure compliance with the relevant health and safety legislation for your state to avoid not only potential injuries in the workplace, but also penalties for failure to comply. Each state has its own regulator, which regulates the system. For example, in New South Wales, the regulator is Safe Work New South Wales. Flexible working arrangements, which, as I previously touched on earlier, are when an employee may request to change their conditions. For example, they may request reduced hours of work or job sharing due to, for example, parenting commitments, their age or disability. Community service leave, as discussed, includes jury duty, but it also includes leave for when an employee engages in voluntary emergency services or emergency management activities, for example, working with the SES or the RSPCA. To be entitled to parental leave, an employee needs to have 12 months service with the company. It is an unpaid entitlement by the company unless you have additional policies in place, but there are government payments available to employees. Notice entitlements refer to the period of notice that an employee, or that is to be provided by employers to employees in a termination and vice versa. This is based on an employee's length of service with the company, and notice needs to be delivered to an employee in writing, so either in person, leaving it at the employee's last known address, or sending it by prepaid post to the employee's last known address. Redundancy pay and entitlements, as we touched on, come from the National Employment Standards. Some awards contain industry-specific redundancy schemes, but that's quite common with your trade industry awards. Conditions of work, we're looking at, for example, hours of work, rest breaks, work schedules. Typically, these come from your awards as well. As we touched on previously, the Fair Work Information Statement, it's a short document. It needs to be provided to all employees on their commencement. And I think a good approach in issuing the Fair Work Information Statement is to provide it along with the employee's employment contract. It's going to reduce the likelihood of this being forgotten. And then moving on to full-time employees are entitled to 10 days of personal carers leave per annum. That accrues progressively based on the employee's ordinary hours. The part-time equivalent, or for part-time employees, they receive that same entitlement, but on the pro rata basis. It's not commonly known, but an employee's unused accrued personal carers leave does roll over each year as well, so something to be mindful of. Compassionate leave, again, it's a paid entitlement of 2 days, and it's provided on each occasion when an employee's immediate family member or household member dies, or sustains actually a life-threatening illness or injury. Now, those 2 days can actually be taken consecutively, or they can be taken separately. And then finally, long service leave, also previously mentioned, it's set out in each state's legislation, and it is an entitlement to paid leave once an employee reaches typically 10 years of service with the company, but there are exceptions to this from state to state, so keep that in mind. So moving on to the next slide, we've got enterprise agreements. So the Fair Work Act allows employers and employees to directly enter into enterprise agreements, and they may either replace the relevant modern award, or they can even incorporate the relevant modern award into that agreement. The enterprise agreements are an instrument that set out the terms and conditions of employment for a particular group of employees or workplace, and they create a workplace-specific safety net. Now, that safety net needs to exist above the National Employment Standards and any applicable modern award. The enterprise agreements, when negotiated, it is negotiated directly between employers and employees, and the process to do so is set out in the Fair Work Act. However, unions quite commonly are a party to enterprise agreements and their negotiations. So with enterprise agreements, they're assessed by the Fair Work Commission to ensure that employees are better off overall and that it meets the BOOT, so the better off overall test, under the enterprise agreement than if the modern award had applied. Quite often, enterprise agreements will contain higher rates of pay to make up for less favourable terms in another aspect, like penalty rates, for example. So what to do, or what if you get it wrong? So we'll now discuss a few major risks facing employers, and this includes probably something you've all heard of is unfair dismissal, adverse action, discrimination, and bullying and harassment. So a major area of concern is unfair dismissal. Unfair dismissal rights are not an automatic entitlement though. So in order to have access to unfair dismissal rights, an employee must have completed a minimum period of service. The minimum period is 6 months service for employers with 15 or more employees, and it's 12 months for employers who are considered to be small businesses with fewer than 15 employees, so 14 or less. There is a further exemption to unfair dismissal rights, and that's for employees who are not covered by a modern award and they earn above the high income threshold of $142,000 per annum. So to avoid an unfair dismissal claim, you need to follow a fair process in relation to dismissal. Process is absolutely key. I can't stress that enough. You're going to be handing an employee a claim on a plate if you don't follow a fair process. So the appropriate process is going to be dependent on the situation though. I guess the most common that we see are redundancy, performance management and disciplinary. So while unfair dismissal is that primary claim that employers are worried about, there is a different type of claim which an employee can make regardless of how long they've been employed, and that's an adverse action or general protections claim. So from an employee's commencement date, they have this entitlement to workplace rights and protections, including access to a benefit such as personal leave, safety in the workplace and freedom from discrimination. If action or even threatened action is taken by an employer against the employee's workplace rights, or if action is taken due to a protected characteristic, then it gives rise for the employee to make an adverse action claim. To avoid this type of claim, you'll need to prove that there was a valid reason for the dismissal, for example, if it was relating to performance or misconduct, and that the reason does not relate in any way to the protected characteristic. So moving on to bullying, it's always been protected under the work health and safety legislation. However, since 2014, workers have been able to make claims to the Fair Work Commission for an order to stop bullying. This type of claim, it's relatively cheap and it's easy to lodge, and so we're seeing a rise in the number of claims and more generally just allegations being made in the workplace. So bullying is defined as when a person or a group of people repeatedly behave unreasonably towards a worker or a group of workers at work, and that the behaviour creates a risk to the health and safety. Harassment is defined as unwelcome conduct that offends, humiliates or intimidates a person, and it's related to a protected characteristic under anti-discrimination legislation. So for example, gender, race or ethnicity. Examples of bullying and harassment include aggressive or intimidating conduct, unreasonable work expectations and exclusion from social events. Bullying does not, however, include reasonable performance management. So reasonable management actions that are conducted in a reasonable manner are not bullying. In the advice team, we see a lot of employees who are being performance managed, making claims that they feel bullied. So be assured that reasonable management action like performance management, provided that it is conducted in a reasonable manner, is not bullying. You just need to be conscious of how and where you're giving the feedback. For example, giving constructive criticism in private is more appropriate than the opposite. So I guess employers need to ensure that you've got policies in place around appropriate conduct and enforce these policies at all times. It is actually of particular importance as well that these policies address conduct and conduct on social media and internet use. Okay, so moving on to the real estate industry and the summary of the key changes, I guess the part you've all been waiting for. There are a number of recent changes that have been made to the Real Estate Industry Award, and these have come into effect on the 2nd of April. If not understood or implemented properly, they can actually be quite harmful for your business. So the changes include the introduction of a broadband classification structure, increases to the minimum award wages, changes to commission-only arrangements, so specifically changes to the minimum income threshold amount, and no casual commission-only employees. Prepayment of annual leave is now banned, which means that there's no more use of the all-up commission rate. And finally, the introduction of new allowances, as well as modification to existing allowances. So starting with the classification structure, after extensive consultation, the Fair Work Commission have decided to introduce this broad band classification structure to simplify the previous and quite complicated process of classification. So the new system determines that an employee's classification is according to the individual employee's level of skills and responsibilities. The old classifications have now been integrated into this new structure, and the new classification called Real Estate Employee Level 4, which is your in-charge level, has been incorporated. So the classifications are as follows. We've got Real Estate Employee Level 1, which is your associate level. Then above this is Real Estate Employee Level 2, that's typically your representative level. Moving on from that is Real Estate Employee Level 3, that's your supervisory level. And then Real Estate Employee 4, which is the new level, is the manager in charge level. Okay, so under the new structure, employees are placed into one of those just mentioned classifications, and they perform duties within the level of skills and competence for that classification. So we'll take a look at these classifications in a bit more detail. Level 1 is mostly engaged to assist and work under the supervision of an employee at a higher level. A Level 1 employee does not have responsibility for listing or selling of real estate property or business, or managing rental or strata community title properties. So common job titles for a Level 1 include your property sales assistants and your property sales associates. Above this is Level 2, and a Level 2 employee has responsibility for listing and selling of real estate property or business. They'll be responsible for helping clients to buy real property or business, or for managing rental or strata community title properties. They may also be responsible for sourcing and securing new property management, so again, strata title management. So your common job titles for the Level 2 are property sales representative, your real estate salespeople, or even business development managers as well. Then above this, we've got Level 3. So an employee at Level 3 has responsibility for the allocation of duties, coordination of workflow, checking progress, quality of work, and resolving problems for employees at Level 2. And your common job titles for Level 3 will include property sales managers, property sales supervisors, and property management supervisors. And then moving on to Level 4, that's your employees who are engaged to be responsible for ensuring that the business complies with its obligations under real estate law. So they're classified at the manager in charge level then. Typically, an employee at Level 4 will hold the relevant license. And so common job titles include licensee in charge and agency manager. So moving on to the minimum wages for these classifications. Again, the Fair Work Commission has reviewed the nature of work performed by employees in real estate and the level of skills and responsibilities involved in performing their work. They then compared this to different industries and occupations and determined that it was appropriate to increase the minimum wage as follows. So for your real estate employees sitting at Level 1, being that associate level, and prior to them having reached 12 months service, the minimum weekly wage is $728.20. Your real estate employee at Level 1, so that same associate level but after having completed 12 months service, they'll be entitled to $768.60 per week. Your real estate employees at Level 2, being that representative level, are entitled to $809.10 per week. And your real estate employees at Level 3, being that supervisory level, are entitled to $890 per week. And finally, the real estate employees at Level 4, being the in-charge level, will be entitled to $930.50 per week as a minimum. So these changes will actually require you as employers to reclassify your employees and as a result, adjust the minimum rates accordingly. Moving on to commission only, the Real Estate Industry Award is the only award that permits commission only payments. The award currently has previously, I guess, has a number of terms that need to be satisfied in order for commission-only agreements to be permitted. In addition to that existing criteria, to engage an employee on a commission-only basis, after the 2nd of April 2018, it needs to be shown that during any consecutive 12-month period in the preceding 3 years that the employee receives a salary, which is inclusive of commissions but excluding statutory allowances and superannuation, equals to 125% of the minimum award rate for the employee's relevant classification. So this percentage of 125% was increased from the previous percentage of 110%. As an employer, you're no longer permitted to prorata the minimum income threshold amount for accommodation of employees engaged on a part-time basis. And further changes mean that casual employees are not permitted to be engaged on a commission-only basis under any circumstances whatsoever. So finally, the applicable rate of commission has been varied from 35% of the employer's net profit to 31.5% of the employer's gross commission. Moving on to prepayment of annual leave. So under the newly introduced changes, the all-up commission rate in commission-only arrangements needs to stop. It can't continue. This is because such practices have actually been deemed unlawful and inconsistent with the National Employment Standards, which are the 10 entitlements that we went through earlier in the presentation. So this confirms the approach that was taken by the full bench in the case of Canavan Building Proprietary Limited. What this actually means is that commission-only employees need to be paid their National Employment Standards entitlement at the time the entitlement is taken, and so they can't be paid it in advance anymore. This includes entitlements like annual leave and personal carers leave. So existing employees who are currently being paid this all-up rate need to be transitioned to the compliant arrangement. And I guess my recommendation for solving this problem is to pay the leave when it's taken and then reduce the commission paid to the employee by the value of that NES entitlement or the leave that was taken. This is going to give you the same overall effect. Okay, so the Fair Work Commission have also introduced an annual review for employees who are engaged on a commission-only basis. And what this means is that as an employer, you're now obligated to assess your commission-only employees' remuneration every single 12 months, so annually. If it's demonstrated that the employee's gross income falls below the minimum income threshold amount, then the employee can't continue to be lawfully employed on a commission-only basis. If the employee fails to satisfy this criteria, they need to be converted from the commission-only arrangement onto a salaried position in accordance with the wages that we previously went through. So in light of this requirement, I do recommend for you as employers, if you're not already doing so, take a more proactive approach with performance management. And that's to ensure that you don't end up with a non-profitable arrangement down the line. Okay, so with regards to allowances and post-employment commission, in addition to the changes that we've just previously discussed, new allowances have been incorporated into the award. So these relate to the new introduction of criteria regarding the reimbursement for an employee for use of their own mobile phone for work purposes. Okay, so the introduction of new allowance to reimburse employees who use their own motorbike as well for work purposes. Following termination of employment as well, an employee is entitled to be paid a proportion of any commission in accordance with the terms of a written agreement, so long as if the employee is terminated for serious misconduct, that there was a legally enforceable contract in place at the date the employee was terminated. And then in all other cases, in circumstances where there was a legally enforceable contract in place prior to the expiration of the exclusive agency period. So to clarify, an exclusive agency period means the period for which the employer has the exclusive right to sell or lease a property under the executed and valid agency agreement that was in effect at the same time of the employee's employment when it ceased. So some questions to ask yourself in light of the recent changes, I guess, and to protect or to best protect your business. Do you have contracts and policies in place? And if so, do they protect you? If you do, are your employment contracts and policies compliant with the Act, the award and any other legislation? Are you aware of all of your employees' entitlements? And are you fully across the changes to the awards? Have your employees been provided with the Fair Work Information Statement? Do you know how to run a performance management meeting? And finally, do you know how to prevent claims for adverse action and unfair dismissal? So here at Employsure, we provide your business with compliance, advice, representation and insurance. To assist with the compliance side of things, Employsure will complete a review of the existing documentation and processes that are currently in place in your business, if any, and then we'll use that as a basis to create a tailored suite of documentation that's specific to your business and the relevant legislation. You'll also have access to our unlimited advice line where you can speak with experts regarding all of your employment relations and work health, safety advice matters. And should your employee make a claim, you can feel rest assured that professional legal representation in courts and tribunals will be provided. And then further, in addition to that, your insurance will provide you with the comprehensive cover if faced with a claim. So to conclude, the changes that we've covered in this presentation, they're now effective and so they need to be adhered to. So that does now conclude our session for today. We will be in touch